wanted to make a case for that particular matter, Mr. Chairman, before he comes in. So if I may be allowed, Mr. Chairman, it's a matter of law, it's a matter which touches the Constitution. So we have a prayer to make, Mr. Chairman.
And that's why this is my advisor. It's about law. Let him advise and then
Mr. Chairman, the issue is about making a prayer for a constitutional reference, and we pray that we be permitted to do so, Mr. Chairman. And if it's a matter of constitution, it takes precedence over any other issue, and that's the reason we are seeking for your audience to permit us to make a case for a constitutional reference led by my colleague here, Council Kalibala. That is our prayer, Mr. Chairman, that we make a case for constitutional reference. And if you do permit, Council Kalibala will proceed to take lead in this, in light of the ruling you have made, Mr. Chairman. And I would like to emphasize that where a constitutional matter has been raised, it takes precedence over any other matter. So we beg that you permit us, Mr. Chairman, to proceed to urge out the case for a constitutional reference.
I have no problem with your submission, Council, but what I'm saying, I have finished the ruling, let him advise, and then you will be given time if it is allowed.
I think, sir, if he has any points to raise on matters of law, the procedure is that you can urge out your case, the state will respond, and this court will also rule on that matter, whether what you have raised requires a reference to the Constitutional Court or not. So you can proceed.
Hold on. Unless you don't know his role, maybe he has advised. That's what I wanted. I think the council can proceed. I think. Go ahead.
Thank you, Honorable Chair. Honorable members are to seek for a reference on a number of matters. The ruling has itself interpreted articles of the Constitution and found them inapplicable. That role is a role that is reserved for only one court in this land, the Constitutional Court. But Mr. Chairman, I want to preface my application for a reference by taking the court to Article 208 of the Constitution. That article, Mr. Chairman, establishes the UPDF. And it spells out a number of very good attributes. Those attributes, in fact, distinguish the UPDF from other previous forces of a similar nature that we had. So they are quite impressionable, they are quite useful. We think that they are amazing attributes to have. I have found them also on the UPDF website. So the UPDF itself is aware of what these attributes are. One of the most important attributes in Article 208 is that the UPDF is subordinate to the civilian authority established under the Constitution. Mr. Chairman, what that means is simply that the force, its members, and its organs are all subordinate to. And in fact, the courts, I will be referring you to a number of cases, the courts have made pronouncements to that effect, that in the finding that you have jurisdiction, the General Court Martial is putting itself above civilian authority. And I will explain what that means. Mr. Chairman, our Constitution is a very, very important document to us. The preamble tells us all the things that were wrong with this country. It tells us the things we aspire to. And it also says these are the ideals we should pursue. And in saying so, it wasn't about 1995 when it was promulgated, but it was to continue up to eternity. That same document also gave us a chapter 4, which covers many articles on human rights and so on. I'm going to refer to 28 shortly. But the force, the UPDF, must live by what the Constitution declares. In addition to what I have just said, that same Constitution says that the rights of all persons, including accused persons, are inherent, so they are not granted by anybody, not any organ, not any person. They are inherent. And they can only be taken away in the manner that the Constitution has said they can be taken away. So I will start with Article 28 on the right to a fair hearing. Honorable Chair, the right to a fair hearing has been described as, that Article 28, as a culmination of Uganda's struggles against forces of tyranny, oppression, and exploitation that brought about unconstitutionality and political instability. It is one of those articles that cannot be derogated from. So there are no circumstances at all under which one can ignore or disapply or fail to observe that specific article. And one of the most important aspects of that article is in Article 28:12. Article 28:12 provides that except for contempt of court, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed by law. The emphasis is on the defined. It is what we are dealing with. So Article 28:12 requires that every offense is clear. The idea around definition is that when you read it, you know what conduct amounts to an offense and what conduct does not amount to an offense. And it cannot be derogated from. So if we have a situation where it's not clear, then we are derogating from Article 28:12. Mr. Chairman, the charge sheet has an offense which is described as offenses related to security. It is contrary to Section 128, 1F of the UPDF Act. Paragraph F is to the effect that if you do or omit to do anything with intent to prejudice the security of the defense forces, you commit an offense. If you do or omit to do anything. So you could walk into, as a civilian, I could walk into a military barracks. I could be charged with that offense.